Leigh Rothschild, appreciate you being here today and having this discussion. I think it's funny sort of how we came into contact with one another. I wrote a blog post about you back in March of this year, I believe it was. And then I received an email out of the blue. I believe the subject line of the email was your article on me. And I was very collegial and I think very kind and fair. And I thought I was kind towards you. But the funny part is, I represent NPEs. I represent defendants in NPE litigation, and you are an NPE. So our interests are diametrically opposed to one another, and yet here we are talking about things and talking about the subject matter. And I just think that's great, and we're civil at it. So welcome, and thank you for joining us.
Diametrically opposed, and yet we're both very involved, make our living out of intellectual property. And I respect your knowledge in that area. So it's always great to talk to a colleague, whether you're on the right side, wrong side, middle side, or bottom side.
Right. And I think there are problems in this industry, and we come at it from different perspectives. And so hopefully we can discuss that and maybe not solve all of the world's problems in one fell swoop, but at least come to some sort of a discussion and back and forth on that people can be educated on. But I've been yapping for a bit. Maybe you can just describe yourself, what you do for a living, sort of who you are, that kind of thing.
Right. I've been an inventor since I've been 17 years old. My first patent was issued, probably an inventor even before that, but my first official patent was filed when I was 17, I think issued when I was 18 or 19 on quadraphonic stereo. So I've always been, I'm not, professionally trained as a patent attorney or an engineer. Actually, my degree is in history, and then I have a graduate degree in business. But I love technology, and I've loved to see it. It's been a major theme of my life. I'd like to see it as it progresses. So I've tried to contribute in various areas, none of which I have any, hopefully I have some competency, but none of which I have any credentials in any of those areas. I sent you a list, actually. I'm proud of some of the areas I've invented in. Currently, I'm holding about 150 patents that are solely invented by me, with many more that are on file with PTO. I just love to be in areas, particularly that I don't really know about, so I can do research and learn about it. And when it's appropriate, file a patent. I've also set up a company now to enforce the patents, license the patents. We have some excellent people that are working with me, excellent law firms around the country. We have an affiliate office in London, another one in India. Our main office is in Fort Lauderdale. I very much enjoy, learning about the IP, licensing the IP. Proud to say that we have licenses with a good chunk of the Fortune 100 and even a bigger chunk of the Fortune 500, where we've licensed not only my inventions, but other inventions patents that I've acquired. Along the way, I had the honor of being on a gubernatorial board and also being named as a technical advisor formally to President George H.W. Bush at the White House. So I guess I have a bit of a technical background, and happy to be on the Zoom today with you, Pat.
I appreciate
even though sometimes you may be on the wrong side of history, so to speak, or of IP history.
Always the right side, always the right side, representing the good guys. But we'll get to that. I guess one thing that I think. So let's start with the basics. Would you agree you are a non-practicing entity, or do you make products and sell them? Maybe I'm wrong on that.
Well, that's a good point. Well, from time to time in my career, we've made a lot of products, actually. Earlier on in my career, I was involved as CEO and chairman of a large computer software company. There were no patents in that company, but a lot of technology and some really great products that I'm very proud of at the time. After that, we developed the idea of scanning QR codes and tying them to the cloud. Not the QR code, because that was invented a long time ago, but the idea of using mobile devices to scan. We have a number of licensees in that area. That company was a public company, became almost $1 billion publicly traded NASDAQ company. So those were products that we had IP for, and we were, not in any way in NPE. Additionally, we have patents now that we're holding that we do have products for. So not totally an NPE. And of course, like anything else, it depends on how you would define it.
Yeah. And the way I look, and I want to distinguish between non-practicing entities generally and then patent trolls, as that term is used, more narrowly. Because I think those terms are two different things, and not everybody understands that distinction. What I perceive to be a non-practicing entity is a company that derives a large proportion of their revenue, if not all of their revenue, off of patent licensing. The typical scenario is a company that either buys or invents so as to acquire a patent, and then sues and then obtains licensing revenue from that patent. To me, that's a non-practicing entity. And to be fair to you and other non-practicing entities out there, not all of them are these nefarious beasts that they've been portrayed to be. And to me, I came from a family of educators, and universities in many ways are non-practicing entities. They don't make anything, but they license their technology. There are many large companies whose sole revenue is the licensing of technology, and they don't really make anything. They just license the technology. So I don't necessarily think an NPE is a bad thing. I'm not calling you names just yet, Leigh, but we'll get to that in maybe a minute. But the idea is that there is this category of non-practicing entities, and the perception is that's where you fall. And I appreciate the history of what you've done in terms of the more tangible and even intangible products that you've created. It is my impression that your primary form of revenue, at least right now, is asserting patents and deriving revenue from those patents.
That would be a fair statement. I would point out, as you enunciated, that there are major companies that have huge sources of revenue, IBM being one of them, one of the huge patent licensors in the world, Hewlett-Packard being another, and a number of other companies. Now, of course, Hewlett-Packard and IBM also have products and services, so I'm not claiming that they're NPEs, but they certainly license their patents. They're certainly not reluctant to sue on their patents, Hewlett-Packard or IBM or some of these other companies. So in that regard, it's a little bit blurry, But yes, absolutely, if you're trying to ask, does a good proportion or most of our revenue come from the licensing of our intellectual property, that would be a correct statement.
And then I think what seems to make you different, if you will, is that a lot of NPEs find a patent, buy it, and then assert it. And it's churn and burn. It's plug and play. They do that over and over again, some for larger amounts of money, some for smaller amounts of money. You are more of an inventor, where you invent the patents, file them, obtain the patents, and then assert them afterwards.
Yeah, I think that is a major difference. I'd like to be known, for my career as an inventor, because that's primarily what I do. But here's the interesting, conundrum. You invent, you find yourself as an inventor. If you're lucky enough, if I've been, to be a prolific inventor in a number of areas, as I said, over 100 plus patents, with many more on the way. The question, Pat, is what do you do with the patents? Can you start businesses with all of them and create products? I've done that with some of them, as I told you, with my public company, done that with a couple of other things. But on the whole, you're going to want to, make sure that your inventions, particularly when you believe in them, go out into, the industry, either for use in the industry or perhaps they're already being used. So you want to, in that case, see that the companies take licenses to your intellectual property, which, as you know, as an attorney, have every right to do. You have every right to do if they're infringing your patents under the law, under the Constitution. So the question is, what do you do? And the answer is, and this was, the situation, how it developed with me. I found myself with all these patents. For a while, we weren't doing anything with them. I was starting companies, and I wasn't an NPE, Pat, as I said. I was starting companies and developing the products, but at a certain point, I decided to, go into the assertion and the licensing business with my patents, strictly with my patents. Then people realized that we were good at what we did, and offered us other patents for sale. And I was interested intellectually in some of that IP because it was areas that, quite honestly, was fascinating to me, from medical devices, which we're now doing some work in, to a number of others, to computer servers and the interaction between the servers and the protection that the servers offer. Not an invention of mine. We've done quite well in that particular area. So it was a matter of seeing, could we help some of these other inventors that are out there monetize their intellectual property. So all along the way, I'd have to say that I'm very proud of what we've done in helping other people, and also in in licensing the patents, the intellectual property that I've created.
Yeah. So the patents you assert, sometimes they're on behalf of others. You become a licensing arm, if I may use that terminology. Or do you
Well,
buy the
to answer
patents
your
from other?
question, normally in regard to standing, and you as an attorney and I know the meaning of standing, normally will acquire the patents on some kind of in some kind of transaction. So they'll be our patents in terms of ownership, but not in terms of inventorship. And then since we have standing, if there's infringement going on, we'll try to effectuate a license.
Right. And but there have been companies, I don't want to compare you to some of the others, but the IP Edges of the world, and back in the day, IP Nav, and some of these other licensing arms that act as sort of the intermediary between the company who owns the patent and then the actual licensee. It seems like in addition to your inventing, you also engage in that middleman element. But of course, you have to be the owner in order to sit down and actually sue on behalf of them. But it sounds like that's part of it. Okay, interesting. All right, so and I have to look at my notes for this, the numbers. At last glance, and this is from RPX, which I'm sure is a great friend of yours, they said you have 1,249 lawsuits historically. 1,249. 25 are currently pending. 59 patents are in litigation across 49 different entities. That's a lot. I mean, is that accurate, or am I veering into uncharted territory that I shouldn't?
Oh no, it's a fair question to ask me, but I can't give you a definite answer. My staff might know that. I don't know the exact numbers. I'm more, as the creative person that I'd like to be, I'm more interested in analyzing the IP and stuff. I don't focus too much on how many, but I wouldn't say that you said anything that I would say, oh my God, that's totally wrong. So, if RPX says it and you've done the research correctly, it may be correct.
Okay, I mean, the perception from my side of the fence is that such a large number of lawsuits is using the U.S. legal system, which is your God-given right to be a plaintiff. You're doing so in a way that is high volume patent assertion. That people look at that and view it as nuisance lawsuits, and then that's where the moniker patent troll comes from. Do you believe that there's a nuisance aspect of this, or I'm kind of giving you a chance to defend yourself against that accusation?
Sure.
It's out there.
So here's the question, okay? Because I love that question that you've asked. So let me give you a question and an answer. You're sitting in your house, you're sitting in your office, or you're sitting anywhere as an inventor. You come up with a great idea. As you know, as a patent attorney, there's a whole process to get a patent. You're a small inventor in this situation, because I'm a small inventor. I'm not IBM. I'm not Hewlett Packard. I don't have billions of dollars of resources like some of these large companies, like Google, for instance. Okay, so you file for a patent. I want everyone that's listening to this to understand the process. Filing for a patent is not inexpensive. You have to hire a patent attorney usually. So you're putting your money, right on the table with your idea. But does it stop there? No. Do you get the patent right away? Your listeners, your viewers should know that you're talking about years of time, usually, to have a patent. In my case, and I've done this hundreds of times, you're talking about a long and arduous process. Now, does the patent office just issue these patents without looking at them? Let's talk about that for a second. No, they have qualified examiners in these areas that are going to look at it. And most of the time, and this would be a percentage, they're going to reject your application. You paid your money, thousands of dollars. It could be tens of thousands of dollars. All your hopes are with that patent. With that patent, the patent office said it's not valid. Your attorney's going to tell you how to change it. You're going to go through various steps. You're talking about years of work and effort. And all along the way, your attorney's asking for money. Attorneys don't work for free, nor should they. Patent office, in many cases, is asking for more money for continued examination. Finally, the day comes where the attorney submits something, the attorney's happy, you're happy, the patent office. You're talking about years later and dollars later, and that patent is issued. Okay, so now you have, wow, am I proud, Pat? I have an issued patent. This is my first patent, by the way. You know, I'm a little inventor. I don't have many resources. You know, in this analogy, my wife and I, not married, but in this analogy, my wife and I have scraped and saved to get this patent. Now you find that, you know, you contact company X, and you're aware all of a sudden that company X is, doing the same thing that the patent prescribes. So you ask your attorney, you know, because probably he's smarter than you are in this. You know, you ask you, Pat, maybe, you're an attorney, are they infringing? And the attorney says, well, I have to do some work on that. More money. They're going to do, probably, if they know what they're doing, an evidence of use chart, a claim chart, and they're going to establish that this X company is violating it. But you're going to be nice about it. You know, you're not just going to sue them. You're going to notice them, and you're going to say, why are you, infringing my patent? Here's proof of it. You're not just going, at an abstract manner and saying, you're providing absolute proof. And of course, there's laws. You as an attorney, I know that. There's laws that govern, infringement. It's, as I said, patents and patent infringement are covered in the U.S. Constitution. But the company doesn't really believe that you're going to do anything because you're a small inventor. So they throw that letter that your attorney, by the way, you paid a lot of money to have your attorney write that letter, in the garbage can. Well, the question I would have for you after all of that is, what are you supposed to do? So now you're going to sue that company. Your attorney, maybe he's a law firm, that does lawsuits, plaintiff work, because you'll become the plaintiff in this, not the defendant. So you hire another firm or that firm, you pay him a bunch of money. You hope that there really is infringement. So at that point, people are going to say, oh my goodness, you're a patent troll. You have no right. You should let the Googles of the world, the IBMs, the Hewlett Packards, patents really have no value to you. You're a very bad patent troll for infringing your patent. You should allow Google and IBM and Hewlett Packard and Apple to infringe your patent. Don't be a patent troll. So Pat, I don't understand. Wait, let me finish. I don't understand when people call me a patent troll. I have valid patents. I have never sued. Let me make this point very clear to you and the viewers. I have never sued anyone, nor has my company, where we don't have proof of infringement. We've won a lot of suits. We have hundreds of licenses. Licenses are an admission that they're infringing. People won't pay you money if they don't feel they're infringing.
I don't agree with that. And that's, I think, where we draw the distinction, because especially with these numbers, this is what it suggests, that the lawsuits you are filing, or that your lawyers are filing on your behalf, are cost of defense settlement litigation. In other words, a patent owner filing a lawsuit and a defendant settling that lawsuit for less than what it would cost to litigate the suit. And people perceive that as being litigious and frankly, harassing behavior that is becoming of a patent troll. I'm not saying you do that. I'm just saying that's where that term comes from. That term, patent troll, comes from folks who invent or not, they acquire patents, however, then they sue based on nonsensical patents that sometimes should never have seen the light of day. I think you've seen that too. And I'll name names later. I won't include you among them. But the whole idea is to send a lawsuit and say, we can pay your patent attorney a couple $1 million. You can settle for me for low 5 figures. You make the decision. And any defendant's going to settle for low 5 figures, and then the patent owner walks away with that amount of money. And then when you have a large volume of those cases, now all of a sudden the patent owner's making money despite the upfront costs that you already stated. So I think that's sort of, I appreciate you explaining your side of things, but that's sort of the frustration from the defendant side and from these large companies and small companies. Because a lot of times NPEs attack small companies as well, and they're having to pay low, sometimes low 5 figures, but still money out of their capital in order to resolve a suit that they
Sure.
think is complete nonsense to begin with.
Okay, but here's the difference. First of all, we've never sued anyone where there's not proof of infringement. And you as an attorney and your viewers should realize that the courts require proof. You can't just go into court. You'll get slammed and hit on the head and end up paying attorney's fees, as you know. The attorney's fees are going to get reversed or you'll get sanctioned. So you need to have, proof. And any company that you're presenting the proof to has the obligation, has the, position that they can go into court and say, we don't agree. And then a federal judge is going to, because patents are in federal court, not in state court, a federal judge is going to decide. So the argument that, if you have a lot of patents, you're just suing people to sue them to collect, small settlements is not, I can't speak for what other companies do, but I can certainly say, absolutely, that's not where we are, not what we've ever done. We believe that a company is infringing. We have proof of the infringement, solid proof prepared by engineers. We tell the company and present them the proof, and the company has, if they don't agree, the obligation to defend their position in federal court. If they do agree, they'll take a license. If you're asking me why do companies settle with us and pay us, and you're using the logic that they're just paying, they don't believe the proof that we're giving, I can't say what's in someone else's head, but I would say this, I think that a company, any company that we go against, certainly should make sure before they pay us a dime that they agree that, our evidence is spot on, because I wouldn't expect, I tell my staff all the time, Pat, just so you know, we're not suing anyone in any manner if we don't firmly believe that they're infringing. And if they're infringing, we want to recover, money from that company for the infringement, as we rightfully have the right to do. Just like you have the right as a defense attorney in the patent area to defend companies that are not, you're defending companies that you believe that are not infringing. Because I would assume, to ask you a question, wouldn't you think it's fair that if one of your defendants is actually infringing, what you're going to use the law to make sure you screw over the other guy, the plaintiff, even though that the company, the big company that you might represent, the Google or the Apple, they're actually infringing. You're going to use the legal mechanism, I would hope not, to screw over the small plaintiff, us, even though you're aware that they're infringing, so that, that they don't end up paying. I mean, I assume you don't do that, but there are firms that will just say, I don't care if they're infringing or not. We're Apple, and he's, not picking on Apple, nice company, we like Apple. Or Google, nice company, we like Apple. But some of these larger companies, pick on them for a second, they're saying, we don't care whether we're infringing or not. We'll use our big firms, our big law firms, bigger than your firm, Pat, and we know some of those firms, to make sure we don't pay a dime. That's the game. So everyone talks about patent trolls. What about, let's talk for a second about the big companies, and it's true.
I actually have, as one of the questions I was going to ask you, what annoys you most about defense attorneys? And I know that's
I love a defense attorney.
Let me now complain about my side. There are a lot of these large companies who do get hit with a lawsuit and then run the ringer. They increase fees, they increase the cost on the other side. There's an easy solution to all this, and it's fee shifting. Where, Leigh, if you bring a lawsuit to me and it's a weak lawsuit, and my client gets sued, and we push forward and we win, then you got to pay our attorney's fees. And there can be a bond put up front so that we're not chasing after you in order to obtain that fee once the award is given. And then the same thing can happen on your side, where if you sue some large company and they decide to throw it into an IPR and then to turn around and do a transfer motion and this and that and run up your fees in hopes that you'll cry uncle, that you can get attorney's fees out of them if you are shown to have won the case. A lot of my friends on the plaintiff's bar believe strongly in that because they're frustrated for a lot of the same reasons that you're describing. So my question to you is that fair for there to be this fee shifting principle, or is that something that you believe is out of bounds?
Let me answer your first question first. You asked me a question. What annoys me about defense attorneys? Many times they're not as smart as you, and that annoys me because you're
Of
smart.
course not.
So that's why I'm happy to be talking to you today. We've had some weird, I'll tell you a couple of stories that are interesting. Sometimes we'll get licensing agreements, when we agree to settle. We've had a couple of them where, for some reason, in the red lines, the opposite side has made it worse for their position than actually worse. They've crossed out some things, put things, they've gone against their client's interest. I mean, how dumb is that? So that would annoy me, right? When a bad attorney will annoy me. You want to sit down at the blackjack table with everyone that knows how to play the game. I love smart attorneys. I had once an attorney that asked me in one of our matters, in one of our agreements, that they wanted to put in there that, this is a true story, Pat, that we would get an affidavit from everyone I met signing that they were not involved in the invention. Some really bizarre phrase. And we kind of laughed at that, just ridiculous. I don't like working with the opposite side when they don't know what they're doing. I don't like working with real estate attorneys that are trying to handle patent matters, or estate attorneys that are trying to handle patent matters. You don't want to go to a podiatrist for a heart transplant. Probably a bad idea. I love smart attorneys, and I love attorneys that can keep it on, a collegial way. They're really going to do everything they can to protect the interests of their client, and they're just great at doing that. But yet, it can be handled in a collegial fashion, without screaming and yelling and threats and everything else. So that's the answer to your question. That bugs me the most. Love working with smart attorneys on the other side. In a couple of cases, I've hired those attorneys to work for me because I'm so impressed with the work they do. There are attorneys, as you know, that can go plaintiff or defense and switch back and forth. We know.
I certainly do it. I'm more on the defense side, but I've been a patent plaintiff many times as well.
Yeah. So you know
I
that.
understand what you mean about the real estate attorney playing patent attorney. That does not work. It does not work. It's a niche industry, and this is a niche part of the law. If you don't understand it, stay out. And I'm not gonna. I hire when I bought my house. I hired a real estate attorney.
Me too.
To not represent myself there. You can't do this as an outsider. Unfortunately, it requires a little bit of expertise.
And the attorneys that know that are the smartest ones to stay out of it, and the attorneys that are in it hopefully know what they're doing. So that's good. To answer your second question, which is, rephrase the second question again now, if you would.
I'm not sure where the second question went, but I was more just curious as to where you saw problems.
Oh, fee shifting. No, it was on fee shifting. I think that if
fee shifting. I'm curious as to what you think of that.
I think you have to do your diligence as the plaintiff when you file this case. When you file the case, you have to make sure that you really have, good evidence of use. And if you fail to do that, you should be liable. To answer your question, I think that it's important that you make sure that, obviously in the case of prior art, you never know what's going to come down. I mean, prior art is kind of a black hole that people can pull stuff out. But if you've done your diligence and you're looking, you reasonably look for art, you've reasonably established, the best that you can, and you present good evidence of use, and you really feel there's strong infringement, and you don't make silly mistakes along the way. I think because if you do any of that, I think that you should be liable. And on the other side, there's been a whole bunch of, unfortunately, in our business, in litigation period, where the other side, the defense side, and I guess the plaintiff side too, done things that they shouldn't be doing, in terms of, holding back evidence and denying, shredding things. And I mean, there was a judge, I don't remember his name, who was a patent attorney, he went to the bench as a magistrate. Now I believe he works for Google. He used to give lectures around that subject, what not to do in the discovery process. So I mean, I think if you're doing bad things, you should pay for them, to answer your question. I think that's a real good question, and definitely I'm not hedging, notice my answer to that.
I know. Yeah, and we certainly have that to a certain extent right now. Of course, the standard is that if you bring a suit that is objectively baseless, only then are you required to pay attorney's fees. I think some are in favor of just making it a clean If you win, you get the fees. If you lose, if you pay the fees, and it's that simple.
I don't know if I
Then the
would.
risk is on you. If you want to go to court and you believe in your case, the risk is on you. Because the issue now is objectively basis is such a high threshold to reach, number one. And number two, in order to reach it, you have to go all the way through. You have to go all the way through trial or summary judgment. Then you have to have a judge agree that it's objectively basis. So all those things together suggest that it's very difficult to get to that point. The other example that frankly you're well aware of is at the motion to dismiss stage, where if you bring a lawsuit that gets kicked out at the motion to dismiss stage and a judge sees it and decides they're going to kick it out at the motion to dismiss stage, they can then make the decision that it's objectively basis. But to get to that point requires a lot of time, money, and effort. Not every defendant, very few defendants are willing to go that route and take on that amount of risk to get there.
I wouldn't want to, our economy is built on these fantastic inventions that, I mentioned Apple a few times, but I have unbelievable respect for what Jobs and Wozniak did in creating a whole industry, and others as well, people that started Google and Yahoo, some of these other major companies now, Tesla, for instance. So what you don't want to do, by the way, is cause the small inventor, not let them, forgetting us, I'm not putting us in that category now because we're a little larger, but that small person that's in his garage, the Wozniak and the Jobs, who come up with something great and want to protect it with a patent, I don't think you want to do anything that's going to discourage them. So I'd be concerned that if you do a total fee shift, we mentioned prior art before, someone pulls something out of a hole, that they never would really, they didn't have the resources or they didn't look at. I wouldn't want to see that person be slapped with, $1 million in fees, because that's going to mean that the small guy is not going to file. It's going to definitely be an impediment for the small guy to file the case to begin with. I think it's going to be a definite drag on inventorship, which I think is, technology and inventorship is at the forefront of our economy and what makes America, fantastic. So there's a fine line in between, filing some crappy case, and which I agree, where you didn't do your homework and having the judge say you paid the fees, or something you really didn't know about, like a prior art situation or some technicality, or a bad ruling from the judge, where he maybe doesn't understand it. Very interesting. Your viewers should know, and I guess hopefully they do, that federal judges in this country, the federal judges that handle this, are not do not necessarily have any background in patents. In fact, most of the federal judges that are appointed to the bench are not patent IP attorneys. They're not a member of the patent bar. They may have been, criminal attorneys. They may have been real estate attorneys. They may have been transactional attorneys. There's not many that we work with in terms of federal judges that we know, correct me if I'm wrong, Pat, that came from a patent IP background.
It's interesting because on the one hand, that's correct. On the one hand, that most judges who go to the bench they didn't start as patent litigators and then all of a sudden join the bench. I can tell you from my experience, a lot of judges who received patent cases they become a patent judge.
I agree.
Example, Gilstrap in the Eastern District of Texas. We have a judge here in the Northern District of Illinois, Judge Chang, who is brilliant and really knows patent law very, very well. And every time I have a case here, it just happens to go to him. And it doesn't mean that the other judges are scared of it. A lot of the judges, especially here, are very good. They're very bright people, but they have enough experience with patent law to adjudicate a case and to oversee a case. But you're right, that not every federal judge in the U.S. has a background in patent law. And occasionally you do get one who doesn't quite know the law or especially the technology, and is playing a little bit of catch up. But I was surprised, and I continue to be surprised over the course of my career at how savvy these judges have become and how sort of centralized the cases become and sort of going towards the judges that want the patent cases. And you can tell when a judge wants a patent case and when they don't. That's just been my experience. But you mentioned though crappy cases, and so I wanted to bring up my good friends at IP Edge. For those who aren't aware, IP Edge is a large volume patent assertion entity. They don't make anything. They have a wacky corporate system where they sell their patents to entities that then take on a certain amount of risk. I've talked about it a lot in my videos as to what they've done in trying to conceal who owns the patents and where the funding is coming from. And those guys are now getting hammered before the District of Delaware, where that Judge Connolly, is asking them to disclose where's this money coming from, who owns the patents, and IPEdge just isn't showing up to court in order to answer those questions. I've heard various positions on that. I'm curious on yours. Is Judge Connolly going above and beyond his authority by asking for this information, or is this something that you're looking at and saying, IPEdge, why don't you just tell him what he wants to know and move on with your lives?
My position, first of all, I want to say that I have great faith. Someone who was involved in politics a little also from my dealings with President Reagan. I was an informal advisor to President Reagan because my college roommate had a high-level position at the White House. So I was giving President Reagan advice in that regard. And then formally for President, for Governor Bush, and then for his father, George Bush. So I have some political background, and I have, particularly now these days, I have incredible faith in the judiciary of this country. I think they've done such a great job in keeping politics, or attempting to keep politics out of, they're really the bulwark that's protecting our democracy. So unbelievable. And I say to the federal judges that are out there, keep up the great work that you're doing. I mean, I just have such absolute, I want to say that these people that are appointed, whether they know patents or not, are just, usually, almost without exception, really very, very qualified, and have done, a really fantastic job in not only in patent work, but in all work. Really, it is the bulwark, protecting our democracy. So, okay, so when you're before a federal judge, here's my opinion. You better tell him what he asked for. You better be honest. He's got the power, and as they should, he or she. So I think that, upon penalty of injury, you better tell them what they ask. So I think if, in this case, Judge Connolly, I think you said, right, in Delaware,
Judge Connolly,
if he's asking, I think you better be answering. And as far as when they ask, what your connection is to the patents, our policy is full, absolute disclosure, full and absolute disclosure. They want to know, and it varies district to district, correct, Pat, in terms of the disclosure requirements, but you need to tell them what they need to, what they're asking for. And you need to follow the direction that the federal judges are giving you, not only in terms of disclosure, but in anything else, because that's the way to run the case. And that's just fair. You're not in charge; the judge is in charge, and that applies whether you're a plaintiff or a defendant.
Yeah, the folks I've spoken to on the plaintiff side see it as there's a line to be drawn. And when I say the plaintiff side, I mean NPEs who I'm very close, who I know and I'm close to, as well as people on the litigation finance side, because here in Chicago we have several companies, several firms with millions and millions of dollars that they deploy on patent litigation cases. The litigation finance firms here in Chicago, and you probably know who they are, but they always view it as, well, it's one thing to say, is there litigation finance behind this, or who owns the patent? That's one thing. But when you get into the nuances of what exactly is the fee arrangement, what exactly is the relationship and the contractual arrangement between the finance organization, finance firm, and the plaintiff, that's when a lot of folks seem to draw the line and say, well, and they're right, it's just not relevant. So there's a line to be drawn between who owns the patent. You got to know that. As Judge Connolly was speaking to one of the defendants at the beginning of all this, and he asked them, what IPEdge, they didn't comply with this order. And the defense were perfectly fine with it. And the lawyers that bill 3 times what I do. And he looked at them and said, don't you want to know who's suing you? And that really resonated with me, because he was looking out for the defendants and saying there has to be some disclosure as to who's on the other side. And that is one thing. That's one thing that I think is less controversial. Then on the other side is, what is the contractual arrangement between the people who are funding this lawsuit and the people who are standing in front of the judge litigating it? I think that, depending on where you go there, that might be a little bit breach of attorney-client privilege, breach of really irrelevant confidential information. But my understanding is Connolly is not asking for any of that. He just wants to
Right.
know where money's coming from, and IP
Well,
Edge just give it to him. So,
I mean, as I said, when a federal judge asks, you better be, totally forthright and provide what they want. If not, you're not following a very good strategy, and you're going to end up getting in trouble. So that would be my answer. As to what he should be asking, I leave that to, him, and I leave that to, obviously, to other judges who will decide what rights they have. You're bringing up an interesting issue. Does a judge have the right to ask all about the financing and the relationship? And I don't know. I don't know the answer to that, or it may vary. I'm sure the financing companies are not pleased when you get to that level, as you're pointing out, of detail. But I don't know, and I guess there'll be more, cases on that, or case law that will develop as far as that. Would you agree?
yeah, it's funny how litigation finance is relatively early on. Contingent risk insurance is sort of a blanket on top of that. That's relatively early stage as well. And all those things combined together, the discovery issues surrounding them are infinite. But yeah, that it's going to develop over the next few years, I think,
Right.
as those things become a little more popular. They're already very popular, especially with the larger dollar cases. But yeah, I was interested to hear what you thought about that, because that seems to be what's in the news with these large volume non-practicing entities lately. And IP Edge is certainly in hot water, and they stopped filing lawsuits, not only in Delaware but all across the country. It seems like they just gave up, and so it'll be interesting to see where they go from here, because they've certainly been beaten down by Connolly.
I will say this: companies, whether they're NPEs or not, that file cases without proper due diligence, who file cases just to harass the other side, who file cases where there's not an infringement, they don't have solid evidence of infringement, they should be penalized. And I think that's basically goes to the heart of your question. Now, obviously, anything is, if you come in very solidly, and there's a difference of opinion, in Markman or something, that's a totally different story. I think, which again goes to the answer that I gave you earlier. I don't think it's black and white. Someone comes in with clean hands and really good information and goes, a small inventor or any company, and goes against the other side. Should they automatically be, assessed with the legal fees? I'm not so sure of that. But in the case where someone doesn't come in with the facts, and is just filing some bunch of nonsense, absolutely, that gives our whole industry a bad name, and I'm absolutely in favor of that being stopped, and that, right. And I want to make the point here during the interview that I think people should be careful as to what they characterize as a patent troll. Is that,
what's your definition? You've heard the term. I'm sure you see people in your industry who are giving you this bad name. There's certainly defense lawyers in this industry who I have to sort of defend myself against the perspective that they are providing towards me. How would you define a patent troll?
Well, I think it's simple. For that person that I mentioned before, and I gave you a long, maybe longer than I should have, information on that little small inventor, of who's protecting his rights for his invention. I don't think he's a patent troll in any manner, shape, or form. Was Edison? You and I talked about this when we first met. Was Edison? Edison was in court, for a lot of your viewers that may or may not know, quite a lot. The Wright brothers for their aeronautic technology, quite a lot of court. I think they were complaining in the biographies that I read of them, complaining, as I understand it, the fact that they were litigating so much. Are they patent trolls? I don't think so. But to answer your question, so that's my definition of who isn't a patent troll. But for someone that is litigating just to harass the other side, that doesn't have good information, that is willing to just file any garbage just to get some money out of, as you were indicating, out of the defendant. Yeah, I guess that's a term that could be used. They're a patent troll. They're just trying to take money that really they shouldn't be entitled to. That's the way I would classify it. For anyone that's getting money that they shouldn't be entitled to, I would say, yeah, that's a bad thing. But if a company really is infringing, and they decide that they are infringing, And I can't say what's in their head, Pat, as to why they're paying or not. You could say maybe, well, they paid because they didn't want to go through the whole case, or they paid because they really thought they were infringing, or maybe they weren't sure. I can't say what's in the other side. But if a company is if you have good evidence, you believe they're infringing to your dying day, and they pay, I don't think that person is a patent troll. You're defending your rights. Patents, as you know, and your viewers should know, patents are valid until declared invalid. And a valid patent, correct me if I'm wrong, you have every right to assert under the law a valid patent. Now, it's a penalty of risk, because if it's garbage, then you're asserting, your valid patent against something, a product or a service that really you shouldn't be, then yeah, you're at risk and you should be paying a price for doing that. I absolutely want to say that. And I would hope that, that we would never do that. We've dropped, when someone tells us, Pat, if you're opposing us in the future, hopefully not, and you say, Leigh, here's why this claim chart is flawed and we didn't realize it, here's why, here's some prior art, or here's why this element, we don't satisfy that. We never realized that. We've had that happen many times. We will immediately withdraw the case. Absolutely. And again, if it was done, hopefully it would have been done, and we've had it done many times in a collegial manner where both sides agree, okay, so we go our separate ways. And that's it. We didn't sue you. We sued you with clean hands, or we asked you to take the license. Maybe we didn't even sue you. We just sent you a letter with the claim chart, asking you to take a license, and you tell us why you really shouldn't. That's fine. Exactly. Don't go forward then. Don't go forward. We, as the plaintiff, should not be going forward.
Yep. Well, I would say farewell, but my guess is you're going to sue one of my clients at some point. I'll probably depose you in that lawsuit. So maybe better to say until we meet again. And yeah, really appreciate you coming on and discussing this topic. I think it's helpful for people to see sort of the back and forth. I do believe this is an area where most people only hear one side of it. I certainly tell that side. And so I felt like it would be only fair to hear the other side and to get some perspective. So really do appreciate you taking the time to provide that.
Right. And if it ever comes to pass that you do oppose us, as I said, it will be a pleasure, because we like working with smart attorneys on the other side. And I'm sure it would all be settled in a reasonable fashion, one way or the other. So no, it was great to hear from you, and to have this interview, and to talk about what I love really, which is IP. At some point, you should do an interview with someone talking about the process of being an inventor and inventing, because it's a really interesting area. How something, for me, it's fascinating, because you're taking nothing and you're making it something. So
absolutely,
it's
part
magic.
of the equation for sure.
There's magic dust. So thank you for the time today. I much appreciate it. Look forward to talking to you again soon.
You as well. Leigh Rothschild, thank you very much. Take care.
Thank you.